And I can maybe track down one of those seats.
So, Councillor Diodati, thanks. If you're finished, we'll start the meeting. Good morning, everybody. I'd like to call this meeting to order and ask that you please take your seats and sign in and turn your cell phones to silent or vibrate. Are there any disclosures of interest this morning? Councillor Timms.
Thank you, Mr. Chairman. With regard to the item on Regional Development Charge Planning Task Force revised terms of reference and complaint process, I would declare an indirect pecuniary interest because the development charge policies have a direct effect on a family business.
Okay, thank you. Noted. Councillor Diodati.
Thank you, Mr. Chair. I'll declare under items for consideration 5.4, GM7 2018 Niagara Regional Broadband Network, City of Niagara Falls ownership participation in NRBN.
Great, thank you, sir. Seeing no others, there are no presentations or delegations today. There are several items for consideration. We'll put the first one on the floor, CSC C14 2018. That's recommendation for consideration from the Joint Board of Management Niagara Courts meeting held April 30th this year. Moved by Councillor Quirk, thank you. Seconded by Councillor Diodati, thank you. Questions or comments to this item in the speakers list? Thank you. Okay, seeing none, I will call the question. All in favor? Opposed, if any? That's carried. Thank you. CSD 12. This is the item, Councillor Timms, you've got a conflict with, I believe. Regional Development Charges Planning Task Force revised terms of reference and complaint process. Is there a mover and seconder for this? Thank you, Councillor Nunziata. Seconded by Councillor Quirk. Thank you. Take any questions or comments on this item? Councillor Easton.
Mr. Chairman, I have concerns about the report, and so I think that I will start my questions by asking what, if there was any legal counsel commentary on this. I'd like to know what the legal precedent is, if there is one, on the formation of a committee in this way.
Through the chair, I'll begin. Certainly the RDC task force has been in existence for some time. So the report began with just a revision to the terms of reference with respect to the membership composition and the timing of the meetings. So we initially kicked off a revision to those terms of reference to address those two factors. Additionally, there is a complaint process in the Development Charge Act that provides for certain complaints to be heard by some membership of council. So that complaint process referenced the RDC task force terms of reference. So in clearing up that reference piece, we thought it appropriate also at that point then to update the complaint process information and to try to make it a little bit clearer as to who had the authority to hear the complaints. So we've clarified that as well, that it's the committee that has oversight over the RDC task force, which is Corporate Services Committee. And then when we prepared all of that change, we did consult with internal legal counsel. So Donna Gibbs was consulted. She did review it in terms of assessing it from a perspective of compliance with the DC Act. So if there's any other questions that need to be directed to her, I'm sure she'd be happy to take those.
All right, Mr. Chairman, I'd just like to continue with Ms. Chambers for a moment then. When the Corporate Services Committee acts as the review board, if you will, are we acting then as a quasi-judicial body? Okay. Could we have, could we have legal counsel come here to speak
Of course.
to this, Mr.
Thank you.
Chairman? Thank you.
Ms. Gibbs, if you don't mind approaching the podium, thank you.
Okay, through the chair, yes, effectively you're deciding upon the complaints in accordance with the provisions of the Development Charges Act. So you're deciding in accordance with the Statutory Powers of Procedures Act. You're acting as a body, and the delegation provided by the bylaw delegates that authority from council to the body that's been established, which is effectively the Corporate Services Committee, to do so. So you're hearing the complaint. The process would be laid out. The complainant, in accordance with the DC Act, would have an opportunity to make submissions as well. Staff would provide a report with respect to their perspective on the matter and any recommendations, and then the committee would make a decision. And then that decision can in turn be appealed in accordance with the DC Act to the OMB, which is now the LPAT.
All right. Now, Mr. Chairman, in the report then, there is a recommendation that the Corporate Services Committee have additional members added up to the point where it would constitute a quorum of council. Am I correct in that interpretation?
So through the chair, the composition of the committee is 16 members of council at minimum, and that's indicated in the terms of reference, which is Appendix 1 in Section 7.
Right. All right. So that is new. I should consider that as a new piece to the terms of reference?
So I think Acting Commissioner Chamberlain would be better able to address how the committee was dealt with in the past.
Through the chair, the previous terms of reference only required a minimum of 5 members. And as a result of just our experience through the last development charge, background study and bylaw approval, we thought that there would be value in having a broader audience of council at those task force meetings to understand the complexity of the issue. So that was that led to the recommendation to expand the membership from a minimum of 5 to 16, so that at least we'd have a larger representation of council. So when the issues proceed to move forward through to committee and council, there would be sort of obviously a broader depth of understanding of the issues.
All right. Okay, so Mr. Chairman, my understanding is that staff have reviewed a set of circumstances and they've made a recommendation based on, from their perspective, what is possibly, and I don't know whether this is the correct word, the most expedient way to deal with customer formal complaints and even customer service issues around the development charge bylaw. Is that correct?
Through the chair, there was always terms of reference, there was always a complaint process laid out, and it only referenced that the committee that had jurisdiction over the complaint process was the committee that had jurisdiction over the RDC task force. So that was a little vague, and as a result of some previous changes in the terms of reference of the standing committees, we thought best to provide specific clarity that that committee is Corporate Services Committee, and then in doing so, actually clarifying what that committee's role is and how it distinguishes that committee's role from the normal process where committee decisions are then ratified at council. There's a little bit of a different process there, that committee's decisions are essentially deemed final in terms of the complaint process and then proceed to council only for information. So it's not really changing the process, but it certainly is clarifying what was previously established in a less specific way, I would say.
And so from legal perspective, do we have any other committees at the region that function in that way?
So through the chair, given my tenure being relatively short at the region, I can't say for certain that we do. As Acting Commissioner Chamberlain has indicated, this is really in response to the provisions in the Act that require council to hear complaints. So this is the process that's been established and has been established for some time in terms of how we address that in compliance with the Development Charges Act.
Yes, and the operative word is that it is council that acts as that tribunal. Correct, Mr. Chairman, through you?
Through the chair, I would say the process that was established in the past is that, no, it wasn't council, it was the committee, but there was lack of clarity, or it was the Corporate Services Committee. However, there was lack of clarity as to that decision being established as final and council not playing a role. So certainly it is staff's recommendation to continue with that process and just offer the clarity that it is the committee that is making the final decision. And not
All
the
right,
council.
and through you, Mr. Chair, did that committee of 5, did that committee have the final word?
Through the chair, the RDC task force never had jurisdiction over the complaint process. It basically, there's two separate documents, the RDC task force having terms of reference to oversee all matters development charge related. However, there's a separate complaint process that was established, and that complaint process simply said that the body that will have the decision making over the complaint is the body to which the RDC task force reports to, which was Corporate Services Committee. So it's not, the RDC task force is not the one having jurisdiction over the complaint, it's Corporate Services Committee.
Corporate Services, Mr. Chairman, in its expanded numbers or in the duly constituted numbers that normally sit here?
Through the chair, Corporate Services, these terms of reference do not alter anything with respect to the composition of Corporate Services Committee. It's just recommending a larger membership to the RDC task force.
But to the exclusion of all of council?
It's a minimum of 16 members.
Right.
So I guess
Okay,
perhaps
Mr. Chairman,
it could have
thank you
all.
very much for the staff indulgent. This is my personal interpretation of this. I'm very concerned about the direction that this is going, and I will not support this motion for the following reasons. I believe that even though there are very good reasons from an operational perspective to make this recommendation, that if we support this, that it serves to diminish the executive authority of council. I understand that it is an expedient way to have these discussions and get decisions made, but this in no way supports the role of council. By redirecting the core business of council either as a whole or a tribunal or a quasi-tribunal, we're deliberately recommending a slicing and dicing of council, authority, and thereby diminishing the democratic imperative of the people that we represent. And I object to this. And I think that this is really the beginning of attempts to diminish that authority of council. I don't believe that any suggestion of improved customer service is more powerful or superior to council as a whole. And therefore, no matter how long it takes for us to have these hearings, if you would pay attention, Mr. Chairman, I believe that there is a deliberate attempt to diminish the representation that we have as a whole to the people of Niagara. And I would even go so far, Mr. Chairman, as to say that I'm really considering this recommendation to be a form of insubordination, because I believe that what is happening here is a deliberate attempt to create divisiveness at the council level. That's how serious I am looking at this. And
Councillor, if I may, on that comment, it's quite extreme because the decision-making has always been with committee. So there's no taking anything away from council. So I just want to caution on the extreme language until we get maybe all the facts clarified for everybody. CEO, can you confirm that?
Through Chair to Councillor Easton, maybe it's not articulated strong enough in this report. we are not changing the decision-making that has been occurred in the past. So it was always with Corporate Services Committee. What you're asking, if I understand your commentary, is that you would like us to change it, to elevate it to Regional Council, which we could do, if that is the will of this committee. But we're not changing the decision-making. It's always been with Corporate Services Committee. So we've clarified some of the language, but if you want us to bring it up to Regional Council, we can. But my understanding is, maybe it's not written in this report, it was always with Corporate Services Committee.
Mr. Chairman, I understand that, but in the description of changing the Constitution to only include a certain number of additional councillors, that defines for me that there is, whether it's your intention or not, that is the way it appears to me that there is a divisiveness that is being expressly suggested here.
If I may, through you, Chair, to Councillor Easton, we actually we're proposing go from 5 to 16 to make it more inclusive of council membership. So what we're finding is, I think I saw a previous draft, there was commentary, the reason why we had to go from 5 to 16 because there was a lack of attendance, and so some of the meetings were canceled. So we figure a stronger inclusiveness of 16. But that task force would always be reporting to committee. We haven't changed that.
So, Mr. Chairman, through you, I go back to, I understand what is intended. And I understand that there's an advantage, of course, to always adding additional numbers. But when it comes to council, it should be council, committee, or council. And in this case, it should be the whole council that is dealing with this. And I think that any suggestion to change the authority of council in regard to any of these kinds of decisions has to be seriously taken by the council. I understand the recommendation, and I understand that my language is quite strong, but it is a form of insubordination to me because of the way it divides up council. It's either council as a whole that should be dealing with this, or the committee. And the idea that the decision-making would stop at only a portion of council making that decision and it not coming to the whole is unacceptable to me.
So, yeah, if I may. Yeah, that's why we're having the conversation, Councillor, number one, but I got to clarify. Staff bring recommendations forward as they always do, and that I cannot allow that to be classified as insubordination. Secondly, I think Acting Commissioner Chamberlain wants to clarify something, and perhaps the CAO.
Through the chair, there's certainly no suggestion in the report to change any of the composition of committee or council. I think what I'm hearing from Councillor Easton is that you would prefer that council be the body making the decision, not committee being the decision body. That's not, that's certainly within the committee's decision to recommend that it not be committee making the decision, but that decision to make committee the body to decide on the complaints was long established. So it's not, we didn't even change any of that. We just added clarity that as a result of development charges having gone from being part of the purview of planning to corporate services committee, there was ambiguity there. So certainly it was intended to clarify, but if the decision of this council is to do something different than previous councils decided with respect to the jurisdiction over the complaint process, then that certainly can be accommodated and it could be a council decision.
Well, Mr. Chairman,
And through you, Chair, to Councillor Easton, so the fact that staff maintained the current practice is not a form of insubordination. However, it is the ability of this committee to change it. And that if you would like the decision authority body to be not Corporate Services Committee, but to be Regional Council, you're asking for a change, which when you give us direction, we'll do the change. But we've maintained the status quo business practice, and that is not a form of insubordination. That was based on a decision made previously, and that we're still following that business practice.
All right, Mr. Chairman, thank you very much. Can we go back then to the original arrangement whereby the reviews were done by corporate services? I don't know how far back we would have to go.
Through the chair, that is what we're recommending.
No, you're recommending corporate services with the additional, with additional membership up to 16.
No, we're only recommending that the RDC task force, which is a separate subcommittee that reports through to Corporate Services Committee, have 16 members.
Right.
That does not change the composition of the Corporate Services Committee.
Mr. Chairman, I must stop debating with Ms. Chamberlain. That's not my purpose. It's not my purpose. I haven't discussed this with any of my colleagues, so I don't know if I would have a seconder to recommend that this be referred to council.
Sorry, it's not, so I want to be clear. It's not a debate. I think there needs to be clarity on exactly what the recommendation is, because it sounds like there's some other interpretations that are not in line. And if we can ask maybe the CEO to be crystal clear of what exactly the recommendation before us is.
Thank you, Chair. And to Councillor Easton and to committee. The way when I received this report and approved to be submitted to committee, here's how I understood it. That currently, and on your issue, there's other parameters within the report, that currently there's 5 task force committee members.
Yes.
They weren't meeting, there wasn't enough quorum, and but that 5 reports to Corporate Services Committee, recommendations or advice, and then they make the decision.
Right.
The only thing we've asked to change is that 5 go to 16. And then that 16 still has that function. They simply advise or recommend to Corporate Services Committee. But the complaint process is at the task force, and then okay. But just for the composition issue, not to the process of the complaints, just to the composition, we're asking permission from this committee to go from 5 to 16, but with the same function to report to Corporate Services Committee.
Right.
And so on composition, that's all we're asking for. That's the way I read this report. And we could talk about the complaint process. That's another parameter.
Right.
So maybe if you're asking, we could maybe reword this report to clearly articulate that, if you required that type of clarity. But that's what my interpretation of how this report reads.
All right, Mr. Oh, I'm sorry.
Sorry, Dr. Gibbs.
Thank you. Through the chair, I just wanted to provide an additional comment for clarity. In terms of the bylaw, the reason why it says that the decision of the committee is final is because the committee is acting as the hearing body. So from a procedural fairness perspective, whoever hears the submissions of the complainant, receives whatever evidence they want to tender when they're making their complaint under the Development Charges Act, they have to be the final decision-making body. So whereas typically Corporate Services Committee would report into council and council would decide, if Corporate Services Committee are hearing the matter, they have to be able to make the final decision, or else it wouldn't be fair to the complainant, because then effectively they'd be making their submissions to a body that it doesn't have authority to make the decision. So if it is the will of the committee to recommend to council that the process changes, I just want to be clear that then the whole hearing will happen before council, not committee. So they will directly make their submission to council. Council will sit as the hearing body and make the decision at that point. So it would be skipping over Corporate Services Committee altogether. So I just want to provide that clarity that it can be either or, but whoever hears it has to have the final decision-making authority.
Thank you.
Thank you very much, Mr. Chairman. Thank you. My preference then is for the hearing to be heard at council. Through you, Mr. Chairman, what is required then procedurally for us to consider that piece? I doubt it's considered, it would be considered to be any kind of friendly amendment. What would the procedure be?
Well, it may be, if I can provide a bit of a pathway, to direct staff to revise the Regional Development Charges Task Force Terms of Reference and necessary bylaw to take into account where the hearings and council have final approval, and then that revision comes back maybe the next cycle. I don't believe there's timeliness issue on this matter, that it could wait another cycle to prepare the revisions as you're suggesting.
Okay, do you need a motion?
Go ahead, Sheo.
Through you to Councillor Easton, if you look at the report, page 23, the draft bylaw that we've proposed, in the fourth line, I think if you can confirm, you're asking that whereas Regional Council adopted the terms of reference for the Regional Development Task Force on, and then it'd be the date, stating that appeals of staff decisions respecting development charges go to Regional Council. I think that's what you're asking for to change. And so be a change of business practice, and that would be the direction we rewrite the report to reflect that. If that's the will, your will.
So, Mr. Chairman, based on, thank you very much, Mr. D'Angelo. Mr. Chairman, having said that, then if that report comes forward to council for consideration, then we will have a full explanation of what the implications are of that. Is that correct?
Sorry, Council, we're just getting the logistics of where this could go. So one of two pathways. One is to refer to staff. You've been speaking to it for quite a while, so my recommendation is you don't have the ability to refer it at this point. And there is a speakers list, with all due respect. You could possibly also make an amendment right now if you'd like. Perhaps we can get a recommendation of what that amendment could look like for you to make if you want to put it on the floor now.
Through the chair, recommendation 1, that we can say that the proposed updates to the task force be adopted with amendment to have appeals decisions respecting development charge go to Regional Council, and that the necessarily bylaw be prepared, and it'll include that amendment, and then we can bring it back that way. Be adopted with amendments that the decisions respecting development charge appeals go to Regional Council rather than Standing Committee, and we can amend it that way.
Statement number 1 does not change what you recommended in the report. Do you want to show it?
Or you can say that the updates with amendment that the appeals be heard by Regional Council rather than a Standing Committee be adopted. Wherever it needs to go before in advance of it be adopted, I don't think is an issue.
So, Councillor, if you'd like to make that amendment, we can get a draft up or wordsmith it, and then
Once I partially heard Mr. Chairman what Ms. Chamberlain was saying, and it sounded true, and if I could just see it up on the board.
okay. At the end of the day, it would be your amendment, so
Yes.
okay. Mr. Chairman, Councillor Hyde has indicated to me that he will second the amendment. Okay. After you decide to move it, if you do. All right, Mr. Chairman, this is decisions respecting development charges. We're talking here about decisions that are related to complaints.
All right, Mr. Chairman, I'll make that motion.
Okay, so we'll have that amendment by Councillor Easton, seconded by Councillor Height. Okay, we will have to have a separate. Separate speakers list open, please, for anyone who wants to speak to the amendment. Councillor Quirk.
Thank you, Chair. I'd like to speak against the amendment because I think the whole discussion that's been had this far from Councillor Easton has sort of been based on an ignorance of the current practice as opposed to the actual report that's in front of us. Ignorance, a lack of knowledge, that's what ignorance means, Councillor Hodgson. So we clearly heard that the current process is if someone wants to complain about a development charge process, it comes to this committee. And so the discussion where Councillor Easton accused staff of insubordination because she didn't understand the report is sort of offensive to me personally, and surely offensive to staff. Clearly that staff has purely put in front of them their best recommendations, which is what we ask staff to do. With respect to the process, all of us are able to join any standing committee at any time, and we can take ourselves on and we can take ourselves off. We don't need a motion of a vote. We can basically place ourselves and then council approves it. So I think the concern about the regional task force being a quasi-judicial body making a decision or making the recommendation to corporate services to make a decision is with best practices, as opposed to we already see what happens at council when issues come forward and ties up a lot of time and allow for deliberation. All the minutes of corporate services go to council ultimately to be ratified. And if the decision can't be heard there, council could always be referred back to the corporate services if they wanted a different decision or if they felt that the appeal was inappropriate. But at the end of the day, the concern about membership could purely be addressed by making the Regional Development Task Force membership open to whoever wants to be on it and not something that is required for a vote of council, and that would take away the divisive aspect of it. But secondly, I think that our goal, when we've been talking about procedural bylaw review and all that, is to streamline the process and what goes to council and look at things that make it more appropriate. And finally, this council has all sorts of executive authority that we have delegated not only to standing committees, audit committees, staff, CAO, directors and commissioners. We do that repeatedly, and we never takes away our right to take that authority back at any given time in the future if we find the process isn't being run the way we think it is. So I personally think that I'll be voting against this. I like the streamlined process that was in place. I like the fact that people who have concerns know where they go to deal with them. And I like the fact that we actually have a formal complaint process as required by the development charges bylaw. So I think that that's where we should be with discussing this. And also, I do think that Councillor Easton owes the staff an apology for accusing them of insubordination.
So, go ahead, Councillor Easton. I'm sorry. Is this a point of privilege?
Yes, sir,
okay, go ahead.
I did. This recital that Councillor Quirk enters into whenever anyone challenges the status quo is something that I'm not willing to accept.
Sorry, what is your point?
I know the procedure.
What is your point of privilege, Councillor?
My point of personal privilege is that I do not accept Councillor Quirk saying that I have an ignorance of the process. As was shown through the discussion, it wasn't always clear through Mr. D'Angelo and Ms. Chamberlain exactly what the procedure was. I have a concern.
I heard your point of privilege, Councillor. One moment. Councillor Quirk, would you like to comment?
Well, I think Councillor Easton has basically defined the definition of ignorance. We weren't aware of the information that was necessary, right? So that is a lack of knowledge, i.e. the term ignorance. So Councillor Easton has just made my point.
We do have a speakers list. Chair Caslin.
Well, thank you, Mr. Chair, and a lot has been said already. I guess my concern is that we're taking this to a level it doesn't need to be at. It really is just a question of process. This is a process that's existed for a long time. We're simply expanding the composition of one committee, nothing more, nothing less. If we want to change it, we really should pick a forum that's more conducive rather than developing policy on the fly. I'm fine with the changes that have been recommended. If the majority of council is interested in making those changes, I just think that making the changes in the format that we're doing right now is probably not appropriate, and I think there's better ways to do that.
Thank you. Seeing no other speakers to the amendment, I am going to ask for a recorded vote on the amendment. I'll look to the clerk to open the vote when ready. Oh, yes, please. The vote is open. Okay, the amendment is carried. We'll go back to the main motion, please. We have a speakers list there. Councillor Quirk.
I made my point, thank you.
Councillor Height.
No, my concern was that if the committee made a decision, then it went to council, council could overrule any decision of a committee, but when we heard if it's a hearing, then it becomes law, so I'm happy with the amendment, thank you.
Thank you. Councillor D'Angelo.
Thank you, Mr. Chair. Just a couple points. One with it going to, if it passes at council, to go to council. My question to that is, will it be on a council evening or will it be on one of our other evenings? We have 3 council sessions. I'm looking for a little clarity of where this is going to end up, or are we going to throw it on a night that we have 12 delegations and other stuff that's happening? So I like a little clarity, because if we need to, we'll put it on the planning week so that it falls on an off Thursday, so it's not part of our regular council meeting, but it is at council. So a little clarity on that, and then I have some other comments.
I'll look to the clerk to respond.
Through you, Chair, it would have to be heard at a council meeting, could not be on a separate night.
Well, a little clarity on that separate night, meaning it's still a council evening, but not a council meeting, because you can have council meetings on any Thursday that you so please. We have planning sessions, we have budget meetings, so if this is delegated to that particular night, it's still a council meeting, but it's not a regular council meeting.
No, it would have to be either a regional council meeting or a special council. Those would be the only options.
Okay, well then, to make it clear, I'd like to put an amendment here that this is a special council meeting night that will be called on a Thursday, not a regular council meeting.
Yeah, I guess you could put that amendment forward, but I'd leave that to the chair with respect to agenda management. If the chair would like to determine to call a special meeting or not, depending on the agenda of that particular council evening.
I'm just asking that this does not fall on a regular council meeting, because this could be contentious and consume quite a bit of time.
Where would you like to put that amendment, Councillor?
Wherever staff feels it's appropriate. It could be a committee of a whole meeting if that's.
So being advised it cannot be a committee of the whole. It would have to be a special council meeting.
Just put it, I guess the amendment would be that the regional chair would have to call a special meeting of council to deal with development charge appeals. How's that? That gives the authority back to the chair in terms of selecting a night, but then we know it won't land on a regular council meeting.
Have it prior to council? Can you have it prior to council? This is what we do for budget. This is what we do for budget. Like a pre.
Mr. Chair, I have no issue with this going back for further review so that we get all this right, but that was one of my suggestions I just wanted to bring forward. I'll let staff deal with that.
Yeah, they're just working on the logistics and even flexibility to start a meeting at 4:30 perhaps rather than a separate night if possible. I think you made your point, Councillor. If you're fine to leave it with staff or you still want to proceed with an amendment?
Well, no, I think there's the clear understanding from the shaking of heads that they don't want it falling on a regular council meeting night, that it should be a separate night that it falls on. In a Thursday night, not a Monday night or Tuesday night. That was one of the points I wanted to make. The other one was I was a little concerned that I know the motion has now moved in a different direction, but having a regional development charge committee of 16 members, I would find that a little cumbersome when we have 5 that, and you can't make quorum on the 5 that are there. So that wasn't a really good suggestion in moving forward, because I think you don't solve the problem of the lack of quorum on that one. So going to council, you definitely solve that issue. I wanted to make a comment, and I don't know if I could amend it here, but on the Appendix 1, item number 12, it talks about absenteeism for the committee members. And it says, members who miss 3 consecutive meetings without authorization shall be deemed to have resigned from the committee and will be notified of this in writing by the committee chair. Little clarity, what is meant by without authorization? What is authorization?
Thank you for your patience, Councillor.
Yeah,
Get it.
no problem.
Respond.
So there are in section 1 of the procedural bylaw, CC, authorized leave. So means an approved absence that is beyond an individual's control, such as bereavement, serving as a juror or witness, or as the parent of or guardian of a minor who has been compelled to attend court to serve as a witness in any court, an illness that has prevented a member to attend two or more consecutive meetings, hospitalization, and caring for a sick child or parent. So basically, in order to get away, an authorized leave would be if council's granted you a leave of absence, or it falls into any one of those items.
Okay. Well, I just said that it's been mentioned that the lack of quorum. Has there been any adjustments through this process? Have any members missed 3 meetings where they've been replaced by another council member? Again, it was brought up several times that quorum has been an issue with this committee.
Through you, Chair. So if a member wanted to be on the committee, so for example, if a council member resigned from a committee, we would put a memorandum forward stating that, and at the same time asking for that vacancy to be filled by councillors.
Okay, but it hasn't come to that, but I'm hearing that there's quorum issues. I'm just getting sort of a confusing message, but maybe it was once or twice that these meetings weren't proceeding because of lack of quorum. I'm just looking, I don't know who sits on that committee, so maybe they can provide, I don't even know who the chair of that committee is at this time.
Through the chair, the chair of the committee is Councillor Volpatti. Ms. Murphy might have some stats on the quorum. And in general, we attributed some of that due to the timing of the meetings. We're not burning issues with respect to the DC bylaw. However, as we ramped up, we still had some difficulty achieving quorum. I don't know if you have the stats.
Through the chair, I don't have the exact stats in front of me right now, but we can get them. I know Clerks has kept that information, but we did have some challenges in meeting it, and it has been consistent since 2015 in actually meeting quorum for the meetings. Some meetings were canceled actually in advance of the meetings. Some we did have some attendance at the meetings, and then due to lack of quorum, we had to cancel those.
Okay, so it sounds like there's a problem there. I think that needs to be looked at to make sure that the members are attending for whatever reason, if it's meeting schedule. So it just, like I said, I seemed a little odd that there's problems with quorum, but it is what it is at the end of the day. And a couple of my other points have been covered, so I'll leave it at that for right now. Thank you, Mr. Chair.
Point of order, Chair.
What's your point of order, sir?
Sorry, I just want clarification, because I'm looking at the website now. We heard that the membership currently is 5, and the membership listed on the website has 2, 4, 6, 8, 10, 12, 11 members. So it's a minimum of 5 is what the term reference. Thank you.
Chair Caslin.
Have you dealt with the amendment?
We did vote on it, yes. So the main,
There was a second amendment. Did you vote on the second amendment?
He actually, Councillor D'Angela didn't proceed with moving it, and so there was no seconder. So let's get the main motion back up so everyone knows what's on the docket right now. Okay.
Thank you. I was just looking for the procedural bylaw just to make sure I had this right. I'd like to ask if I could please refer this back to staff so that we could give the policy a little more thought, and perhaps if there's some concerns, staff can reach out to those particular councillors and understand what the concerns are to make sure that they're addressed properly.
So there's a referral motion. Is there a seconder? Councillor Quirk. No comment on referrals except for timing. 1 cycle. 2 cycles. Okay. All in favor of referring, please put your hands up. Opposed, if any. Referral is carried. Thank you. CSD 31, debt authorization, 2018 debenture issuances. There's a lot there. Is there a mover and a seconder for that? Councillor Timms, welcome. Moved by Councillor Timms. Thank you. I'm not signed in yet. Well, we'll wait for you. Thanks. Okay. Is there a seconder for this? Councillor Quirk, thank you. If there's any speakers, questions or comments, Councillor Timms.
Thank you, Mr. Chairman. I find pretty instructive and helpful in this discussion of this whole relationship between the municipalities, the local municipalities in the region in terms of debenture or long-term borrowing. The specifically in this particular issue, the St. Catharines is borrowing $16 million, or St. Catharines will be receiving $16 million through the issuance of this debenture. It's on page 5, I think there's where the local area municipalities will be receiving $28 million through the issuance of this debenture, 250 for Wainfleet, 16.8 for St. Catharines, and 11 million for Welland. And my question, though, the report is very helpful, and it says that the municipalities have to go through the region. I think under the analysis on page 31, region raises funds through the sale of regional debentures in capital markets to finance its capital needs and those of the area municipalities. The authority is granted solely to the regional government in accordance with the Act. So in other words, the municipalities have to go through the region in order to do this under the Act. There was a very informative memo on this whole subject at the Audit Committee, which I think comes to Regional Council on Thursday night, this council. And what seems to be the crux of the question is the region, as it's been said many times, just a clearinghouse for funding of for this local borrowing, or are we more than that? And I've seen the documents involved, and they have a term in there, a clause in there that makes it very clear about the notion of joint and several responsibility for the money, for the loans, which to my mind, and I'd ask staff to maybe explain this more clearly, is that when we are in here for 67.2 million in debentures, we're all in it together, So joint and several means that the 12 municipalities and the region have a responsibility for this debentures as a group. So I just ask staff if I understood that joint and several responsibility issue properly. And then the second one is, I've seen documents where the regional chair signs the debenture document and a mayor or all the mayors. In this case, would the 3 mayors be signing the debenture document where for the 3 municipalities that are benefiting to the tune of $18 million? So 2 questions there.
Through the chair, so the first question around the joint and several, I would confirm that yes, in general, it means we're all in this together. So there's some vested interest, I think, as we described more clearly at Audit Committee last week, which prefaced the publishing of this report, that Infrastructure Ontario as well as Standard & Poor's rely largely or to a great extent on the region's financial creditworthiness. So there is some vested interest in all of us working together to make put our best foot forward to keep interest rates low for all the benefiting 12 municipalities. So yes, it's joint and several. The second part of the question, there is an established process which Weir Folds, our legal counsel, coordinates for us, which requires that the local area municipalities have to provide bylaws that are approved by their council, authorizing the debenture of their council. As well as updated statements from the treasurer and the clerk around the annual repayment limit, et cetera. That information then gets forwarded on to Weir Folds in combination with all of the regional information. Weir Folds does all of its due diligence. They ensure compliance with all of the necessary municipal act requirements. And then when they give us the green light, we issue the debenture.
Thank you, Mr. Chairman. I think that helps and hopefully the understanding of this among local councils, local councilors, and region is greatly enhanced through this process and the memo that's coming to council from the audit committee. Because the question to me has always been, is this clearinghouse simply a rubber stamp process? And this report indicates it's far more than simply a rubber stamp. Is it an interference in local finances, or is it due diligence? So it seems to me, by reading this report, understanding this joint and several responsibility, and the memos that are coming on Thursday, that it is indeed a due diligence. I don't see it as interference, and I don't want to be seen as a clearinghouse and rubber stamp authority, because the fundamental basis of the region was that if we were all joint and several responsible, then we've got municipality, we've got 430,000 population working together, providing security that gets everybody a better interest rate, because it's issued on a joint and several liability for 430,000 people as opposed to Wayne Fleet for 6,500 people. And all of that achieves a much cheaper interest rate on the major long-term borrowing, and that was one of the fundamentals of fundamental reasons for establishing the region. And sometimes I think that's been forgotten in the process. I got a city council motion that says region has no authority, unusual step of contacting the local area municipality's lender, and interference. I think that is all of those are a bit of an illustration, and that was a motion put forward without any advice from city staff. So I think really the issue is that the public and the councilors need that kind of bit of refresher on what this relationship is all about. So if staff have any further comment on that, I support the motion here. I think the report is very clear and very helpful, and I think this report should be distributed to the local municipalities. I don't know if we have that practice. I know they've passed their own motions to authorize these debentures, but to have this go back to the municipalities to explain the entire relationship, I think would be very helpful. So I support the motion, Mr. Chairman, as I had moved it.
Okay, thank you, Councillor. Councillor Campion.
Thanks, Chair. A couple of things. Just first of all, to Councillor Tim's comments, to insinuate that local councillors don't understand the relationship is ridiculous. I mean, I'm getting tired of hearing we have to educate councillors. We have to educate local area municipalities. It makes absolutely no sense. We understand. We get it. I have a problem with the report, and I'm asking for direction from you through you to the clerk. There are certain parts of this report that shouldn't be there. What would be the process to have them removed?
Just I want to clarify, Councillor, certain parts of the report or certain parts of the recommendations on here?
Both.
Well, because there's different process, right?
Right. That's why I'm asking.
If it's recommendations, then you don't have to.
Well, I'd like to know what the process would be to remove parts of the report through you.
Okay, I'm going to take a crack at it, and I'm certainly happy to take a
I'd like to hear
it on
from
to
the
the
clerk.
I don't think we can tell staff what to put in the report or not put in the report, but I'll look to the clerk for a response.
Well, I guess more clearly, what's going to be forwarded to regional council, I'm asking. So how do we change what the content of the report is as it moves forward to regional council?
So it's staff's report, not committee's report. We can change recommendations, and we can take recommendations, those are committees, to the council.
Okay.
But the report is staff's report. We can't edit the report.
So I'd like to hear something from the clerk. If you have an answer.
Through you, Chair. It would depend on what you were looking to remove. I mean, the report is an entire package, and part of the decision-making process for committee and council would include all that information. So I would hesitate to say that removing something would be appropriate, because council and committee then wouldn't have the full picture of what staff is asking for.
So, through you, Chair, there would be no opportunity to amend the report? I just want clarification on that.
Go ahead, Seo.
Through Chair, to Councillor Campion, in the event that you are concerned with some of the facts or some of the language or parameters within the report, I would say that you refer the report back to staff and ask for it to be reformatted, or give direction to staff on what you're looking for, or what you're looking for it to be changed.
But that referral still goes to all of council.
Right. So I guess I'm just trying to think process-wise. I can't do a referral because I'm speaking to it. So I think I'll just continue to speak to the
Let us know what the concerns are, Councillor.
Yeah, okay. So really what my difficulty is with the report is Appendix 3 and any reference to the debt risk management framework. So the problem with that I see here is that there's a reference being made to policy that has not been approved by regional council. So essentially usurping or going beyond the requirement of council, regional council as a whole, to determine if they in fact want to implement a policy. And this report is heavily relates to that, or refers to that debt risk management framework. And I believe that's what Councillor Timms was talking about as he was speaking. When he's talking about reports, he didn't identify it specifically, but he referenced it in the sense that, you know, we have to have the authority, you know, the regional council should be overseeing these things, et cetera. That discussion has been had at the audit committee meeting, but it has not been had at regional council. So to taint the report with irrelevant information, because it's not relevant, because it's not approved policy. So the difficulty I have is trying to find a way where we can rectify that situation, because, and I'll be blunt, it appears as though the assumption is that that audit committee report will pass, and now we're basing a decision on that assumption, which then taints the direction of the report. So somebody, you've sort of answered one of my questions coming up, is who's responsible for the report? The report you indicate is the property or is owned by staff. So staff somehow put this material in. My question is, it's not a question, but the point being, it shouldn't be there. Why is it in there? Why did somebody decide that an unapproved policy should be part of a decision? We have existing policy on this right now. If you want to call it rubber stamping, whatever it is, but we have a procedure where this goes from here to the region, to our lawyers, and approval. So I don't want to talk about the audit committee report. We timed out when I was here last time, so I wasn't able to participate in commentary there, but I will participate in it at the regional council meeting. But this is insulting, to say the least. Now, I'm not calling it insubordination or anything like that, but I consider this to be extremely insulting to regional council and to area municipalities, and particularly the commentary that we're hearing from Councillor Timms about the lack of knowledge of lower area municipalities. We are supposed to be partners in this. We're supposed to be working together. We anticipate that we can work together, but this particular way that this has been put together does not exude cooperation and partnership. It exudes ownership, oversight, big brother. This council, regional council, this committee is not the province. This is not the provincial government here. We answer to the provincial government. Both of our bodies answer to that. So the authority lies with the province. They outline requirements, steps, etc. So when we're talking about due diligence in this report, the due diligence falls to Weir Folds, the solicitors. That is the process. We answer as a municipality to Weir Folds. They tell us what they need. They make sure that we're compliant. They ensure that the regional municipality is protected. They ensure that we're not overstepping our boundaries as far as borrowing goes. Our local area CFOs identify what we can and can't do. They take their direction from council. However, they have a strict responsibility because they have to file statements with provincial government indicating here's what our debt limits are, here's how much we're borrowing, here's why we're able to do that. So when this goes to regional council, this report, there should be no discussion on the framework of as it relates to this. It should be, here's what's being asked for. As usual, let's present this, we'll pass this, and we'll send it on to our lawyers to make sure that it's compliant. If we're not compliant, if we don't provide the information to the lawyers, they will reject it. They have an obligation to make sure that they're compliant. So I'm insulted that the reference to this debt risk management framework is included in the report and any reference to it. And I can tell you there's reference that our staff here is working with local area municipality staff to ensure they get all the information so that it fits in with the framework. I'm here to tell you that we're not doing that. The city of Welland is not doing that. So if you read this in that report, that is not a fact. That's not happening. We are providing the information that we're required to provide through this process to ensure that we're compliant. We in no way are participating or supporting this debt risk framework. It's unnecessary, so it should not be a part of this. I'm coming up to my 10 minutes, Chair. I realize that, but again, I cannot tell you how disappointed I am in this report and why I have to assume staff is driving the audit committee report and driving that process to be included in the simple matter of approving our debentures. So there is somehow, that shouldn't be there. It is. I don't know why, but it should be removed. So If it has to get referred back to staff to have that removed, I would be happy to do that. I know we have to issue the debentures at some point soon. We only get one shot a year, and so let's get the debentures done, but let's get that part of the report out of there because it's ridiculous to have it in. And as I say, it's extremely insulting to regional council to assume that a decision is going to be made on that particular framework. That assumption, I'm hoping, is going to be incorrect. And so this whole report should not be tainted by something that may or may not exist. And I anticipate, I'm hoping that it will not exist. Thank you.
Point of order, Chair.
What's your point of order?
Councillor Campion may not be aware there's no time limit at committee for speaking, so if you wanted to continue in this conversation, I didn't want him to feel that he was rushed artificially thinking he only had 10 minutes.
That's not a point of order, but thank you.
I appreciate the comment, and I do realize that, but I said all that I need to say. I don't want to be repetitious. I think I've made the point that I'm very unhappy with the report, and I'm unhappy with staff putting that in the report, if that's who in fact directed it to be in the report.
Okay, so just so everybody's clear what we're talking about, Appendix 3 is a itemized listing of total Niagara debt, Niagara local municipal debt. So I, for one, appreciate that level of information. However, it's titled or framed is another discussion. I don't want to get into detail about all the audit committee recommendations we've heard from Councillor Timms and now Councillor Campion. That's a separate matter that's going to be addressed at the next council meeting. Although I would look to Acting Commissioner Chamberlain for commentary on the appendix.
Through the chair, before I speak to the appendix, I think clarity around Weirfold's responsibility is probably necessary as well, in case I was misunderstood.
Mr. Chair, again, I kind of agree with Councillor Easton from previous on a point of order. I don't want to be debating with staff
Thank you, Councillor. This is not a point of order. Okay.
Well, I think it's a point of order because I believe that this report shouldn't be included, so we shouldn't be discussing it.
Thank you, Councillor. That's not a point of order.
It is a point of order. I think the discussion is out of order because this report should not be.
Councillor Campion, it's not a point of order.
I'm telling you, it is a point of order, Chair.
That's my ruling. You don't want to hear from staff?
No, I'm telling you.
You asked several questions to staff, and now you don't want an answer?
No, I said I wasn't asking any questions.
You did. You asked how many times staff is responsible. I want to know why it's here.
I clearly said I'm not going to ask a question.
You cannot muzzle staff, Councillor Campion. Say whatever you want and muzzle staff.
I still stick that that's a point
of order. You do not, that's not your point of order. You do not have the floor.
You can rule a point of order.
I'm calling a recess, 5-minute recess, please.
Chair. It seems. When we get back, I'll be back.
Thank you, everybody. I'd like to resume the meeting. I'd ask that you please take your seats and sign in. Councillor Easton, you have the floor once you're ready.
Thank you very much, Mr. Chairman. And Mr. Chairman, as per your consideration, I want to apologize to Ms. Chamberlain. It wasn't my intention to suggest that she was insubordinate. I've spoken with Mr. D'Angelo, and he and I are going to be talking about my interpretation in that regard. So my apologies, Helen. Mr. Chairman, in regard to the matter that is before us, I will be very careful with my language because I do not want to escalate this further. I think that Chair Caslin's comment is a point well taken. However, I would like to ask the CAO if, in fact, he plans to take this, or has it gone to the area CAOs and treasurers, and what, if not, what are there any plans for that?
CAO?
Through Chair to Councillor Easton, I did receive a call from the CAO from the City of Welland, Gary Long. He articulated some concerns with the risk management framework, and we thought it would be best to bring it to the June 8th area CAOs meeting so we can have a full discussion on that, where I had suggested that we also invite our treasurers to that. So I invited our current regional treasurer. We put it on the agenda. It will be circulated to all CAOs, and we plan to have some discussion on June 8th on it. Okay. I've asked also further, Councillor Easton, I've asked the audit committee chair that we remove that audit, that framework report to additional cycle of council in order for the CAO to have that wholesome discussion.
Okay, Mr. Chairman, I would like to further reinforce Councillor Mayor Campion's comments about the level of authority that each of our bodies have and how we report to the province. The intent of the audit committee is one of accountability. I understand that, and certainly I think that has prevailed for several months now. However, the necessity of even having that commentary based on the relationship that and responsibilities that municipalities have, to me, is unnecessary. And that is an area that I would like to see a much higher source of interpretation in terms of the legal ramifications of that. This decision doesn't matter if it may or may not have an impact on how other municipalities are going to be affected in other regions. This actually is really quite serious. And I say that quite aside from any accountability that the audit committee believe that they want to exercise in this regard. So I'm pleased that that it's moving out into the area of all of our CAOs and all of our treasurers, because I believe that's where that decision needs to begin. Thank you very much.
Thank you, Councillor. Councillor Quirk.
Thank you, Chair. I'd like to ask through you to Acting Commissioner Chamberlain, the information contained in Appendix 3, is that publicly available information?
Through the chair, that is information that's available on the Municipal Affairs publicly available FIR website.
So one of my questions is when we look at these various indicators that are of critical importance to us as a whole, is that you look at scenario 3, it says this scenario reflects the AR calculation as per Ontario Regulation 403/02, where municipalities must update their ARL for debt as approved for capital works. Previously, when we've approved debt, it's been based on the 2015, when we did 2017 approvals, it was based on the 2015 filing of the ARL and didn't take into account 2016 financial statements and or the updated ARL. But it seems to me that the local area municipalities are required to provide that updated ARL before as approved debt, not when it's issued. Is that correct?
Through the chair, I won't speak specifically to how the municipalities were updating their ARL calculation. However, As you may recall, over the last number of years, when we presented the debenture reports, we did include our calculation of the municipality's ARL, and we were basing it on that regulation requirement, which is the last published annual repayment limit updated for the debt. Some municipalities, and certainly we do both calculations, we calculate what the upset limit would be based on everything that we approve, and we also calculate what we think the number will be based on how we're actually going to debenture it. So we've provided both those calculations, and when we were providing the local area municipalities, we were doing it based on the regulation because we didn't really have all that information as to when the municipalities would be issuing it. So that Schedule 3 is to comply with the regulation in the Municipal Act on the basis that it requires us to update the ARL for purposes of OMB approval being required on anything exceeding 25%. So at least we have clarity, regardless of the different bases that municipalities may or may not be calculating it, we have clarity that that is when the OMB approval would kick in.
And so may I just through you, is that best advice that we've gotten from our legal counsel, that this is what we should have been using all along?
Through the chair, I certainly never professed to be an expert in all regulations and Municipal Act information. However, we had been preparing it on that basis and understanding that it certainly was the most conservative number. We solicited external legal counsel from Weir Foltz to validate the basis of our calculation, and they have confirmed that it complies with the regulation.
So, and I appreciate that. So I think up until recently, this is commentary, not question, up until recently, when we have been approving the ARLs, the debt based purely on the ARL number, we have always been, for the local areas, a couple years out of date because we have gotten the previous year's number. So when we had the whole discussion, and it wasn't an issue until some of the local area municipalities were getting close to that ARL limit where they would have actually had to go to OMB, or if they were doing something to not have that register, like declaring stuff as temporary borrowing where it doesn't go into this number. So I point out that many times I'm here as a regional councillor, and it's not my intention to reach into the affairs of local area municipalities, and my local area municipalities made that very clear. They don't want to be involved in that. However, the issuing of debt is a regional responsibility. That's clearly spelled out in the Municipal Act, and the benefit for the entire region for the lower interest rates, which are spelled out in Appendix 3, based on the fact that it's based on the credit worthiness of the region, not on the local area municipalities, is important to us. So if we are getting to those sort of arbitrary numbers that are set by the province, then we have to be concerned about it. And also, as Councillor Timms mentioned, we are jointly and severally liable for it. So if a local area municipality is unable to or unwilling to pay their debts, it's not just the region that picks it up, it's all the local taxpayers across the entire region. So we have to do our due diligence on behalf of all our taxpayers to make sure that there's not going to be a risk. And I think we've had a conversation, the Commissioner and I, offline about the use of debt and the appropriate use of debt and the terms that are put on debt to when people are extending debt. Grimsby has a high number because we only take 10-year debt at the maximum. That's the most we'll run debt, and that's a decision of the local area council. So our ARL is higher, but only because we're paying that over that much faster, where you have other municipalities that have kept their ARL low by taking advantage of the 30-year rates that are now available and pushing out they're mortgaging their future to keep their ARL low, which again, the appropriate use of debt where and when appropriate, but we have to be aware of that when we're talking about it. And the other thing that's kind of buried in this report about our debentures and the issuings that we're doing, I didn't see here, and maybe I missed it, the amount that we actually pay back this year, so where we're at too. So if I've missed that, I apologize, but that is actually part of the conversation. How much debt are we actually paying back before we take on the debt? And that is also a legitimate conversation to have with our partners. They're taking on more debt, but they're not paying off the debt they have. And the cash flow on a go-forward basis is going to impact the local area municipalities as well as the region. So I appreciate concerns, especially if there's a municipality that falls into the pink and red zone on some of the municipal financial indicators, publicly available. I think it's important that this information is publicly available. I, for one, don't want to bury my head in the sand and just rubber stamp stuff. I think that that's not doing our proper job of due diligence as a Niagara regional councillor. I'm sure it would be easy just to stamp this off and say, well, not my problem, until it is our problem. And unfortunately, it's only been the actions of some of the local area municipalities coming close to the OMB required approval limit that this has brought its ugly head forward. So I look forward to having a further conversation, and as the CAO indicated, the recommendation coming from audit, I'm going to be asking for a deferral for a cycle so the CAOs and the area treasurers can inform themselves and have the debate.
Well stated. Thank you, Councillor. Seeing no other speakers, I'll call the question for a second time. Councillor Timms?
Yes, for a second time. I just want to take the moment to apologize for offense I may have given to Councillor Campion and Mayor Campion. If I use the word all councillors that don't understand the relationship, I apologize for that. I am certain some don't understand the relationship, and this debate has been very helpful to inform them. My reference point, Councillor Campion, was the St. Catharines motions and the statements by several that the region is just a clearinghouse. So I do apologize. I didn't mean to imply that all councillors don't understand this. And I do appreciate that there is we're all getting a bit of a refresher on this relationship. And so I apologize for the offense. I'm sure the mayors are very clear on this, but I didn't mean to include everybody. Thank you.
Thank you. Chair Caslin.
Thank you. Mr. Chair, I would like to refer this back to staff for a cycle, if it's technically possible. So before I do that, I just want to make sure that I'm not stepping out of order.
Acting Commissioner Chamberlain.
Through the chair, just consulted with my team, and because we need to bring the debenture bylaw back and have enough time to bring that back to council, if this doesn't approve at this council and allow the process to go forward, we won't be able to do a debenture issue this year before council goes into break in August. We won't get back here with the July, in time with the July bylaw.
But I guess the benefit would be that, in fact, we do have a policy approved by council. So I guess I have to balance what's more important.
Chair, you still have the floor.
Through the chair, I guess the implications of doing so, will certainly be subject to interest rate volatility, so we could come back in the fall with a higher interest rate, and certainly the municipalities that were issuing debentures on behalf of St. Catharines, Welland, and Waynfleet, the implications on them of not having that cash flow for their capital would have to be assessed. Certainly the requests came from them, and we're supporting those requests in this report.
Thank you for that clarity. And what it sounds like is I certainly don't want to cost taxpayers any more money than necessary, so I will not be referring it. But it is a good lesson learned here that before any policies appear on our either committee or council agenda, that they're approved by council. So this is moving forward. We need to take special note that let's make sure the policies are approved before we put them on our agendas.
Thank you, Chair. Seeing no other speakers, I'll call the question. All in favor? Opposed, if any? That's carried. Thank you. We have GM 7 2018 Niagara Regional Broadband Network contract. Mover and seconder for that. Thank you. Councillor Quirk moved, seconded by Councillor Conk, seconding this. Okay, thank you. Any questions or comments to this matter? Okay, seeing none, I'll call the question. All in favor? Opposed, if any? That's carried. Thank you. GM 8, restricted acts after nomination day on municipal election. Mover and seconder, please. Thank you, Councillor Quirk. Seconder. Councillor Timms, thank you. Questions or comments on this matter? Seeing none, I'll call the question. All in favor? Opposed, if any? That's carried. CSD 24-2018 Municipal Capital Facility Agreement and Designating Bylaw. This is a good news item. Moved by Councillor Timms, St. Catharines. Councillor Height, seconded. Thank you. Questions or comments to this matter? Seeing none, I'll call the question. All in favor? Opposed, if any? That's carried as well. Thank you. We do have several consent items for information. It's the will of committee to move all of them in block. Thank you, Councillor Quirk. Seconded by Chair Kazan, thank you. Questions or comments to any of the information items?
Just, Mr. Chairman, thank you. The Shape of Niagara public open houses, how are they being publicized? And I know the public sometimes takes a bit to get their attention on these things. So how are we publicizing those?
Mr. Tamming?
Councillor Timms, through the chair, we'll be doing two pushes on social media with paid advertising end of May, early June before the events, as well as we're going to send that information down to the local area municipalities so they can distribute as they see fit, as well as some newspaper ads in early June to highlight the five events taking place.
Thank you. So are we covering print media in any way?
Yes, that's the newspaper ads.
Right.
Those will run early June.
All right, thank you. And Mr. Chairman, while I have the floor, the item 6.3, the employee diversity practices. Let's thank staff for putting that together and advising us. We had met with the Niagara Anti-Racism Coalition a while ago, and they had expressed some concerns and wanted to know what the region was doing in this area. So I'll be able to, once we receive this, pass that on to that coalition. And if they have any further inquiries or further concerns, I'll be able to bring them back. Thank you.
Great, thank you. Any other items on the information items before us? Seeing none, I'll call the question. All in favor? Opposed, if any, that is carried. Is there any other business? Councillor Height.
Yes, I was somewhat offended a number of weeks ago when I got a copy of the flyer that was sent out by a counselor, and I was waiting to review our expense account information, which was just released in the last few days. I was trying to get it, and it was just released, and I took a look at it. Since that time, we've got 2 other flyers that have been distributed by counselors, and a third one that's been prepared. I'm not sure if it was been distributed yet. So I reached out to former regional communications employee and asked the question regarding flyers like this and anything that had regional logos on it. And I was told that it wasn't done in the past. And anything that had a regional logo that was included was carefully reviewed and would never be self-serving. I believe a few councillors and staff have crossed the line here. I believe they violated the code of conduct of members of council. I believe that they've used their expense accounts, I'm assuming, for preparation, production, distribution, and have violated our code, our policies. It may even have violated the Municipal Act as far as municipal elections. I'm not sure of that, but I'm sure someone's going to look into that. I'm requesting a report from staff with the following information for our next cycle because this is important. Who authorized the preparation of the flyers, ads, and at what cost? Are there policies in place before the region logo can be used? Because I understand there were. Who authorized the printing and at what cost? Who authorized the distribution and at what cost? Have any councillors attempted to expense them? And I don't think, in fairness to people that are planning to run for re-election, that it's clear in the policies that we shouldn't be using anything that we have an opportunity to use and have an advantage over any individual who would like to run. And in this case, it looks like pre-election campaigning or election campaigning, that's up to someone else to determine. But most importantly is that the interpretation of our policies that would ever allow something like this, we have to find where the loophole is and stop it before any further abuse is done. And I'd like that report to this committee for the next cycle, because the Election Act was clear, May the 1st. We had information from our GM regarding what's allowed in the Municipal Elections Act, and we've got to clean this up right now, because this is my integrity, this is all of our integrity is being questioned by the use of our resources that I think have crossed the line.
Thank you, Councillor. And if there is a report coming back, I'd ask that it include whether the purchase of itch cream is appropriate, or the purchase of mugs with regional logos to be handed out to constituents is appropriate. I'll look to the CEO to comment.
I'm asking for staff report. I'm not wanting a debate on it. And if we want to debate it, we don't have it
Councillor,
in front of us.
every time, if I ask staff to comment, it's not a debate. CAO.
Through you, Chair, to Councillor Height, you're asking for a staff report commenting on council behavior. I would submit that is not the role of staff. If you have an issue with the code of conduct, my advice is that's an integrity commissioner complaint.
I said I didn't want to debate. I'm not asking you for a comment on code of conduct. I'm not asking you for a comment on the expense account policy. I'm asking you specific information about who authorized and at what cost. And when I get the information, I'll determine what I do with it. And the public will as well.
Councillor, I suggest the cost does come out quarterly already. So I think maybe your question is who authorized it?
Well, in some cases, if something was just printed last week, by our policy, it won't be public for 4 months from now. And that will be in close to the election, and the public should know about it now.
It would be published in July, as I understand it. Yeah. Okay. Councillor Diodati.
Yeah, Chair, my feelings was this is not something for staff to discuss or debate. This is an issue. If we have an issue, a concern of anything like this to do with the election, it goes to the Integrity Commission. This is not the appropriate place to be discussing this. Pass it along to the Integrity Commission, and they'll make the determination. Let's not make it political.
Thank you, Councillor. Councillor Quirk.
Thank you, Chair. Just I understand Councillor Height's concerns. I'm the one who put out my flyers, my information, which is purely within the realm of my decision to do. I authorized them. I had them printed. I actually contacted the communications department. They were too busy to get it within a deadline, so I used an alternative source. I expensed it. The costs were about $1,500 to publish 10,000 of them, distribute them. It's the same thing that my predecessor did when she published our newspaper ads, so and expense them back to the region. So I just took past practice as the best way to do it. I would have preferred to use a newspaper ad, but the company that delivers our local newspaper is also the flyer delivery, so it was cheaper to go that route than to take out a page ad or a half-page ad in the local paper. So I'm happy to have the conversation with whoever wants to have it, especially my constituents, who most of them said thank you for updating me with the information and approving it. So if the issue is with using the regional logo, my interpretation is clearly that if I'm putting out information as a regional councillor, I'm entitled to use the Niagara regional logo, and if I've been told otherwise, I would be happy to follow that regard. If there was anything in there that may be interpreted as providing information to my constituents, or if they feel that if some other council wants to take effect to it, I believe the appropriate course of action is to take it to the Municipal Audit Committee during the election campaign when that's formed, because that would be where the complaint would be. And otherwise, if you don't like how I'm spending taxpayers' money, then I'm sure my constituents will tell me that when the time comes. So I will never apologize for informing my constituents about issues. Councillor Timms asked specifically about how we're getting the Shape Niagara conversation out, and I was very clear. One of my flyers, the backside of it, is directing people to the regional website to contribute towards the Shape Niagara survey. So I have no problem asking my constituents for feedback, and I have no problem expensing the cost to get that information out to them in the first place, as was past practice. So I'm sorry that Councillor Height is offended by informing constituents. I'm sorry to hear that.
Thank you, Councillor D'Angelo.
Thank you, Mr. Chair. I'm just wondering, I haven't seen all the copies of these brochures that went out. Can they be provided to all council members? And if council members want to do the same, who do they speak to? They just go to the communications department and ask for what they want to send out? I'm just looking for a little clarity on that, if you could direct it to the appropriate staff.
Through Chair to Councillor D'Angelo, should you wish to do that, we'd if you're going to utilize our printing services, our communication staff, we just like some advance notice to put it in queue of our job work orders. But we could send you a sample that you could use, should you want to use it. So we can give you samples of our formats.
Well, that's what I'm more concerned about, is the information that's being provided, if that could be distributed to all the council members so that everyone's aware of it. And then they can design their own brochure and go to the print shop if they want so. Okay. Thank you.
Councillor Timms.
Thank you, Mr. Chairman. I appreciate Councillor D'Angela's request here, and I understand Councillor Height's perception that it's not been common practice in St. Catharines for sure, or in the region. But it is common practice across the province, and many municipalities expect their elected representatives to issue newsletters, news pamphlets, information, especially in the days now when people are, the media spread is so wide, anything from Facebook to the daily newspaper. Who knows how people are going to absorb this or get informed on the council activity or the councilor's activity. So we get into a little question period now in between when nominations open, or when, as this report suggests, when does the election period start? And maybe that's where there's some concern or questions. But I would like to, as Councillor D'Angela has said, what are the parameters that councillors can use? Common practice around the province and many municipalities, just not common practice at Niagara Region or in St. Catharines for sure. Right? Quite right, Grimsby, Councillor Zimmerman and Chair Zimmerman did it many times, and it was not an issue. So now it's an issue maybe just because we're after the days when we're in this election year. But to hear, and maybe it should be included in the councillor's information package as to what councillors can do through the clerk's office. We get our business cards printed. You can get regional, councillor Tim's regional councillor on regional letterhead with regional logo. There's a variety of services that maybe haven't been used in the past, but it's, as Councillor Height has raised, there's a concern that it's something maybe not commonly used in St. Catharines for sure, that we should all be aware of and be better informed of. So it doesn't become an issue of who's doing what right and what's proper and what's not. So I'd appreciate if we can get that kind of guidance, as Councillor D'Angela has requested. It would be helpful to all of us, I think.
Thank you, CAO.
Through your chair to Councillor Timms, I do know that the deputy clerk is working on a orientation package. We're completely overhauling it to meet exactly what you're asking for. It's a project in process.
Well, I think we need something more immediate, though. Thank you.
Councillor Nunziata.
Thank you, Mr. Chair. I know the residents of Fort Erie are very appreciative of knowing the good work that this council has done, specifically to projects in Fort Erie and specifically to the region as a whole. So I know my constituents are very, very grateful when they are updated. And any flyer that goes out there, it's almost a repository of information. Over the course of 4 years, there's a lot of information that's come out of this council. And unfortunately, residents, for one reason or another, don't have access or don't know where to look for it. So it's almost like a repository of information. So my residents are very, very appreciative of it. That's my one comment under new business. And I think we're still under other business.
Yes, we are.
Okay. It was brought to my attention, and specifically to Bill 148. Now, Bill 148 got incredible publicity with respect to the increase of minimum wage, but there are some other aspects of Bill 148 that, for one reason or another, have kind of slipped through the cracks. And I don't want to argue or debate the merits of Bill 148. My personal opinions are it was very ill-conceived and very poorly thought out. But I did have a concern with respect to one of the aspects of Bill 38, which is the 2 days of personal emergency leave must be paid. This is applicable to all employees who have been employed for at least 1 week. That's 2 days of personal emergency leave that must be paid. So I applied that recommendation in Bill 138 to a real life scenario. And it was specific to the Peace Bridge redecking project that's going on right now. And I made a phone call to Mr. Ron Reines, who is the general manager at the Buffalo Fort Erie Bridge Authority. And he says that one aspect of Bill 148 alone will cost $200,000. Now, just so we're clear, it was a fixed contract in 2016 that was entered into with American Bridge Construction. Recently, American Bridge Construction has passed on a bill for $200,000 because of that amendment in Bill 148. So it got me thinking, what other infrastructure projects, what other municipal projects will that piece of legislation affect? Because at the end of the day, for every infrastructure project that this council moves forward with, for every infrastructure project that a municipal council moves forward with, that cost has to now be built in. And I would love to know what the impact to the taxpayer that piece of legislation will have. So I'm hoping either just through a staff report that can come back to this council and help me understand that impact moving forward with any municipal infrastructure project, any regional infrastructure project that we now have to build in to that cost. And I'm hoping once we get that information that that can be passed on to the new government, if there is one at the province, and hopefully alleviate some of those concerns at the municipal level with municipal councils that now have to budget for that, that very, very poorly thought out piece of legislation. And just so we're clear, when you're talking about this piece of legislation, I don't think it was intended for iron workers that are making $40 an hour to take advantage of that. So again, there has to be some kind of definition that goes into that piece of legislation, and the impact to this council and to other municipal councils is going to be astounding, in the millions of dollars. So just one project alone, I give you one example, $200,000. Here's the new bill. You have to pay it, and you have no recourse. So I'm hoping that through just staff direction, we can get that report as far as what the impact of that cost going forward will be. Thank you, Mr. Chair. If it requires a resolution, then I'll be more than happy to make notice of motion and bring forward that motion at the next available opportunity.
Through the chair, I guess I would just offer some commentary in terms of being able to quantify that. I think I would certainly agree that there's financial implications associated with this, but from a contractor perspective, you'd have to understand how previous collective agreements, because I know from our example, so if it's not a 24/7 operation, if you're taking those 2 days, maybe there's productivity but not a real cost associated with those 2 days off because you don't have to replace. But depending on how contracts are priced and depending on the requirements of staff on site, so to create the level of depth of analysis of all the contracts, that would be an insurmountable task to be able to identify that. But certainly, like from a regional services perspective, we've done some analysis, HR has done analysis in terms of the cost associated with Bill 148, not just those 2 days, but minimum wages. Those all have implications in service delivery, and I know many of the municipalities are assessing how they deal with contractors are coming back and saying because minimum wages increase, we need to increase the price of our contract. I'm sure we'll see some of those contract renewals come in with some escalated costs, but also then it depends on how much somebody's hungry for the business, whether or not they build that into their contract. So there's so many elements in there that I think it would be an exceedingly large challenge to try to quantify what the impact of that would be on the region's budget.
So with respect to those comments, and I appreciate those comments, and I understand that it's a very arduous task to bring forward those numbers. I'm going to assume, if it's now legislated, that at a minimum work of 1 week, that you are now eligible for 2 paid days, that it's a simple formula. And I'm going to assume, if it's built into legislation, why wouldn't any employee take advantage of that piece of legislation? So I understand there's many moving parts to it, but I've given you a very concrete example of how one infrastructure project has a dollar amount and a dollar impact to it. So I'm hoping that we can somehow bring forward some numbers that represent the impact to the taxpayer.
Okay, thanks, Councillor. I think there'll be maybe a memo from staff or something like that to provide a little bit more information. Okay, thank you. Councillor Hodgson.
Thank you, Mr. Chair. And I'm going to step back one subject here because taxpayers really are concerned. And I think taxpayers will be pretty concerned about the notion that somehow pamphlets are being expensed. And so I'm just going to leave it at that. But I do have a question for staff. I had an opportunity to read one of those alleged pamphlets, and it asserts the regional tax increases. However, it forgets to mention the impact of uploading. And we all know, we've gone over this, it's a decade now since the uploading plan was implemented. And we know that all of the benefits of uploading have remained at the regional level. And so each year we used to do, and I think we did in our last, we certainly mentioned it, the impact in the last round. And so the average tax increase in real terms is much higher than what's being portrayed. So if a regional logo is going to be placed on pamphlets, what fact checking are we doing to ensure that we aren't making misleading statements?
Councillor, if you're referring to my quote-unquote alleged pamphlet, all the information I received was from regional staff. And also,
The point of the matter is you were trying to strike a comparison with your local municipality.
Councillor, if you'd like to get into a debate on my pamphlet, I suggest we actually include it on the agenda and then discuss it, so then everyone can see what we're talking about.
This is other business, Mr. Chair.
If you want to get into debate about the material I put forward, put it on the agenda and make it public for everyone to see.
And the problem is that when the logo is made, is printed, and it's going out as an official informative piece of information for the community deserves the truth and not misleading statements.
It is 100% fact. To suggest it's anything other than 100% fact is completely irresponsible.
It's interesting, in your particular different reality.
It's not different. It's fact. The numbers are the numbers, Councillor. Seeing no other business, we do have confidential agenda. Is there anyone who would like to speak to any of the confidential matters this morning? Councillor Diodati, thank you. So I'll need a motion to go in camera, moved by Councillor Diodati. Is there a seconder for that? Councillor Quirk? Well, we're going to all of them, yeah. So all in favor of going in camera? Opposed, if any, that is carried. Thank you. I'll look to the clerk to advise when we're ready. Okay, thanks everyone for your patience. We are in open session once again. I'll look for a mover and seconder for the closed session matters that we discussed already. Moved by Councillor Easton, seconded by Chair Caslin. Thank you. Questions or comments to these? Councillor D'Angelo.
Yeah, Mr. Chair, so as part of the update to council, the report regarding the business licensing transition project, only the matter respecting labor relations should be in closed session. I think council should be receiving a report that is not, a lot of that stuff we discussed in closed session should have been in open session. So I think there should be a report coming to council with all the items that are open session, just discussing about it, the fact that the municipalities are going to be working with regional staff on this issue. I think all that stuff has to be in open session. So I'm hoping that come council meeting next Thursday that there is a bit of an open session report regarding that.
So we are going to get back a addendum memo, and perhaps that can be made public at the least. Okay.
Yeah, I'll leave it up to staff to put what they can, but I think it should be as much made public as possible.
Okay, thank you.
Thank you.
Councillor Timms.
Thank you, Mr. Chairman. Same subject, and you covered it when you said that the covering a memo with will be provided to council. The notion that the memo can be public and cover whatever can be public would be helpful. And only at that point, once I've seen the memo, would I support the receiving the report as it's written.
Okay.
Thank you.
Thank you. Seeing no other speakers, I'll call the question. All in favor? Opposed, if any, that is carried. Thanks, everybody. Our next meeting is June 6th. Call this meeting adjourned.